Okay.
We'll wait just a few seconds for the attendees to populate if there are any. Oh, I'm expecting John Anderson from Texcom, but he's not here yet. Here we go.
There's a couple.
Yeah.
Okay. The November 2021 meeting of the California Law Revision Commission will come to order. A quorum is present. Do we need to call the roll to establish a quorum?
We haven't in the past.
Okay, well, a quorum is present. First order of business would be approval of the minutes of the October meeting. Is there a motion? So David moves.
I move to adopt.
And Jane seconds.
No proposed revisions from the staff.
Correct. Any proposed revisions from commission members? Seeing none, hearing none. Brian, want to call the roll?
Yes, Commissioner Carrillo,
Aye.
Cubas,
Aye.
Jenkins,
Aye.
King,
Aye.
McAllister,
Aye.
Miller O'Brien, you're muted. Commissioner Miller O'Brien, she must have stepped away.
Mhm.
Put her down as not present. Commissioner Rubin
Aye.
and Commissioner Simpson.
Aye.
Okay.
Administrative matters report of the executive director.
Yeah, thank you. So the biggest news is that we have 3 commissioners whose terms ended at the beginning of October, who are now well into their 60-day statutory holdover period. One commissioner, Commissioner Cubas, I believe, indicated that she had applied for reappointment. Is that correct?
Yes, it's in process.
Great.
Okay. You might want to check in with them, because if they don't get it done before December 1, then you're out for a year. It's a draconian rule.
Yeah, I interacted with them on Monday, and so they said they're working on it, and we'll get that done. Yeah.
Good. And Commissioner Rubin, your term has ended, and this is, I believe, your last meeting, since we're not going to be meeting again until December. So I hope it was a good experience, and I appreciate your service to the people of California.
Thank you. It's been
And for those of us who are veterans of Marin County, are glad to have shared some time with you as well.
And Commissioner Miller O'Brien is still not showing as present at the moment, which is a shame. Perhaps we will hold off on thanking her until she's back in the meeting. So that's, as I said, the most significant administrative development is that we're going to be down a couple of commissioners unless the governor acts before the December meeting date to appoint new members. And I haven't checked recently with them, so I assume that that's in progress. In part, I assume that because Commissioner Miller O'Brien just 2 days ago has announced that she's been appointed to the California Access to Justice Commission. So she's been appointed to a new body, which suggests to me that they are on top of our class of commissioners who are on their way up. I'm happy to say the staff's back up to its full complement. Steve rejoined us after having missed one meeting for medical reasons. Kristen's back after an extended leave of absence, and Barbara has returned from Spain. So welcome back, everyone, and I expect that going forward we'll start getting back to our normal stride for work output now that we got the staff back.
I did want to say, if I can interrupt, I do need to log off at 11 because now that we have in-person events, I have to go to an event. And so I'll be logging off at 11 a.m.
Okay, thank you.
I would expect that we'll be done by then.
Yeah.
Appreciate that.
Let's strive for that.
Yeah. To facilitate that, agenda item number 6, the fish and game law item, was pulled from the agenda. So I don't see anyone here from the Department of Fish and Wildlife, so they got the message, and we'll only be going through the first 5 items. The Just an update on the committee on revision of the penal code. They met on Tuesday, and that's going to be their last meeting of the year, and they approved their annual report. They also released a report on the death penalty earlier this week, and I sent you all links in case you want to see how nice their graphic design is compared to the commission's graphic design. But I'm not bitter. And their final annual report should be released in the next week or two for consideration and submission to the legislature and the governor. Those are the only administrative items I have to report.
Okay, thank you. Any commissioner suggestions? Studies, topics? Going? Okay. Meeting schedule, Brian?
Yeah, thank you. This is memorandum 2021-53. And the memo presents three general alternative approaches to scheduling our meetings for next year. And that's because we're still in a period of uncertainty about whether or not it's going to be possible and desirable to go back to in-person meetings. And I don't know when that's going to happen. But I hope it will at some point next year. So the first option is just to stick with our existing practice of monthly meetings entirely by teleconference. And I've proposed dates for that for 12 meetings. The second option, which I don't know that we're ready to seriously consider because conditions may not permit it, would be to go back to in-person meetings every other month. And if the commission decides it wants to try to do that, it would be simple to just strike every other meeting date from those that I proposed. The third general option is to wait and see, which effectively means begin by following the monthly meeting practice, approve dates for that, and then as conditions change in 2022, we can reassess, and if it makes sense, transition from monthly meetings to every other month. So Commissioner Creo has a hand up.
David?
Sorry, I thought you were done.
No, that's fine.
It seems to me like option one and option three are basically the same. If we choose option one, we may wind up getting preempted by something. So my suggestion to my fellow commissioners is let's just pick one. My personal preference is option one. I would love to see you all in person, but I think there are some significant logistical advantages to having remote meetings. And I suspect that the law will allow us and practicality will require us to keep doing them for some time. So I suggest we just pick option one. And if we're forced to reevaluate at some point based on a change of law or conditions, then we do that, which is basically option three.
That makes sense to me too.
I
Anybody
agree.
else?
I agree. I think it's good. I think it's also fiscally a good move because there's less travel time or travel expenses for us to have to claim. So as far as a burden to the state, it would be significantly less. We continue to meet on Zoom like this, and it doesn't seem to have been any kind of impediment to people joining in. In fact, probably easier for some people than having to have them travel to
Sure,
Sacramento.
that was Sacramento.
Yeah.
What about the dates?
I'm good with the dates.
Any concerns about the dates? Fine by me. Anybody else?
Brian, does staff and you have a preference for a full day meeting or a half day meeting by Zoom? Just philosophically speaking.
Philosophically speaking, I don't really have a preference, except that if we do it by teleconference, I think a full day meeting would be exhausting.
Totally agree.
All right, that was what I was looking for. Okay.
Okay, so do I hear a motion for option one with the proposed dates?
I will move option one.
Moved by Carrillo,
Second.
second by,
I will call the roll.
I'll second.
Commissioner Carrillo,
Aye.
Commissioner Cubas,
Aye.
Commissioner Jenkins,
Aye.
Commissioner King,
Bye.
Commissioner McAllister,
Aye.
Commissioner Miller O'Brien is still not with us. Commissioner Rubin,
Aye.
Commissioner Simpson.
Aye.
Okay,
All right.
that item is done.
Item 3, California Public Records Act cleanup. And that's Barbara, I think.
Yes, that's me. This is an informational memo. I think you've been previously informed that the both bills relating to the California Public Records Act recodification were enacted. The bill that consisted of conforming revisions had 462 code sections amended, and it had a subordination clause in it because preparing bill conflict amendments for that size of a bill would have been just prohibitive. As a result of the subordination clause, about 50 of the conforming revisions that were in the bill were chaptered out by other legislation that amended the same code sections. And so those conforming revisions will have to be reintroduced in the coming year. There were also a couple of code sections that were not included in that bill that cross-refer to the California Public Records Act. The reason they weren't included is because they were supposed to set recodification of the Public Records Act became operative. The sunset dates were extended by the legislature this past year, so necessary to make those codes. And then there may also be some new sections in the code that cross-refer to the California Public Records Act that we haven't discovered yet, things that were just added this last year. The staff needs to do a search for those and compile the legislation that needs to be introduced this coming year. And then we will keep you posted on as we move forward on it. I don't know if there's anything to say about this memo, except that if he has, I'm happy to.
Barbara, your audio was choppy, at least for me. So just to recap, the memo was short. You've read it. It's we'll need to do a cleanup bill to fix the conforming revisions to CPRA that were chaptered out, or that new provisions that reference the old law, or provisions that we thought were going to sunset and then didn't. So we'll take care of that.
Great. Any questions or comments from members? Okay. Thanks, Barbara. That was very helpful. I'd never seen that kind of a subordination clause before, so that's pretty impressive.
Yeah, the tricky thing is when two bills with subordination clauses conflict.
Right.
Which is actually not as uncommon as you think, because the maintenance of the codes typically has a subordination clause. Looks like Barbara's a ghost hunter right now.
That's okay. No, I did bills that were identical bills. This was back when we implemented Proposition 98, identical bills, and both were adding a bunch of the sections to the ed code, the same content, the same section numbers. And so we had two chapters it still do for a long time on Prop 98 implementation. And we elected to go, all the subsequent amendments were to the one that was chaptered last, which was mine. Yeah, we've had to deal with that sort of stuff before.
Yeah.
So thank you, Barbara. Okay, item 4, stock co-ops and uniform TOD.
Okay, so this is memorandum 55 and a supplement, first supplement. So just to recap, at the last meeting, we considered public comment from the Trusts and Estates section of the California Lawyers Association, TexCom. And the commission decided to move forward with a proposed law, but to adopt a new drafting style rather than enacting the stock co-op statute as a standalone statute. It would be implemented as sort of as a tweak to the existing revocable transfer on death deed statute. And the commission approved a substantive change. So we made a modification to the rules on resolving conflicts between a revocable transfer on death deed and another dispositive instrument, removing a requirement that the other instrument be recorded in order to be in contention, and reliance on the general rules for contests. So that was approved by the commission, and the staff was directed to prepare an implementing draft. That draft is attached to the main memorandum. Another decision that was made at the last meeting was that the staff should look harder at an issue that TexCom had raised about whether it was sufficiently clear that the revocable transfer on death deed statute was subject to a general rule of construction in the probate code section 21134, which dealt with the effect of loss of specifically gifted property while a person is conserved or subject to or otherwise incapacitated. And we did decide to take a look at that. And in the main memo, I report a new wrinkle on that issue. And then the supplement, and I'll circle back and we can deal with these in more detail, but I just want to sort of lay out the landscape first. The supplement sort of upsets the apple cart from the first memo, where I had been presenting this draft for approval by the commission, in which case we'd have a final recommendation. The supplement raises another issue about the draft that we haven't previously considered and that I think needs discussion. And I didn't quite get to the point where I have a recommendation, because I want to hear input from stakeholders and commissioners and see where we think we ought to go on this, and then either bring it back for more discussion at the next meeting in December, or a revised draft if that's appropriate. I'm generally feeling like putting the brakes on a little bit on this study, because at the last two meetings, we've dealt with previously unexamined issues that I thought were pretty critical. And we could resolve all those issues this year and go forward next year with a bill. But there's no deadline on this study. So it's possible too that in December, we'll decide to continue to chew on it if we see other issues or the possibility of other issues. So that's the general scope. So the first issue in the main memo is whether you have any concerns about the draft that's attached to that memo with the language or expression or the narrative explanation. I don't think we're going to be able to decide whether to approve it until we've considered the issue in the supplement. But at this point, it would be appropriate to consider whether to make any changes to it, just based on your read of it.
Any commission members have comments or issues they want to raise about the tentative, whatever, the draft in memo 1? Seeing none, hearing none. Okay.
So the other issue is
Jane. I'm sorry, Jane.
Oh, no, that's okay. I'm sorry, Brian. I wasn't sure if TexCom was speaking to this, so I wasn't sure if you were done. Pardon me.
They do have a person present in the audience. He can raise his hand if he has any concerns about the draft.
Thank you.
Not seeing any. Okay. Thanks, Jane. So the second issue discussed in the main memorandum is the treatment of probate code section 21134. And as I explained in October, that is a general rule of construction in the probate code that operates as a kind of safety net for a person who's the beneficiary of a specific gift. If the property to be gifted is otherwise disposed of or lost, while the transferor lacks decision-making capacity and is being protected by a conservator, trustor, or attorney in fact to a durable power of attorney. So if the person making the gift isn't able to sort of police the gift and something substantial happens to defeat that gift, you don't know what the transferor would have intended had they had capacity. So the law provides this special safety net and says, okay, you don't get the specific asset beneficiary, you get a general pecuniary gift of the same value. Okay. So sensible law, should it apply to the RTOD deed? Does it apply to the RTOD deed? And the issue that we left unresolved at the last meeting is it sufficiently clear that a transfer of real property by an RTOD deed is a specific gift? Okay. And we were going to talk about whether to clarify that point. In subsequent informal communication with John Anderson, who's our liaison to TexCom right now, he raised a new issue, which is how, if 21134 applies, how does it work if applied to an RTOD deed? The concern being that an RTOD deed only disposes of one asset. There's nothing else governed by that instrument. So if the RTOD deed, the specific gift made by the RTOD deed fails because the property's gone, where does the pecuniary gift come from? It can't come from the other assets under the RTOD deed because there are none. Distinguish that from, say, there's a will that disposes of the testator's entire estate, and a specific gift fails, and then it's obvious that the pecuniary gift is going to come out of the remainder of the estate. It's all one big ball of assets. So Mr. Anderson was asking, well, how would this work with an RTOD deed? Is it sufficiently clear what the answer should be? And my response was, well, I think that's a good issue, but I think it also exists for other kind of testamentary instruments. The same thing could happen if you had a trust that only disposed of your house, and then your house burned down while you were incapacitated. What result? Where does the pecuniary gift come from? The trust doesn't have any money, just cash in it. Presumably, it should come out of the general probate estate in that situation. I think that's the answer for the RTOD deed too, if there is one with sufficient assets in it. But the statute doesn't speak to that situation either. And so what I say in the memo is that while I think Mr. Anderson has raised a concern that is germane to the RTOD deed, I think it may also have more general relevance to estate planning as a whole. And if that's the case, I suggest that we take that issue, sever it from this study so that we can slow it down and look at it in the context of estate planning as a whole and get broader input on what people think the rules should be. Does anyone have any questions about that explanation? Okay.
Seeing none, David?
Yeah, I think I ultimately arrived at the same place. It occurred to me while I was looking at this, why don't we just include I guess you could call it an SOL clause. If the house is lost or destroyed, by an act of God, a flood, brightside of fire, then you're just out of luck. There's no alternate source for the gift, so the gift fails. But that seems harsh, and I'm sure there are factual scenarios that would contravene testamentary intent as a result of that clause. So I ultimately I agree with Brian. I think it's more complicated than a simple carve out clause so that this other section doesn't apply, because I think there are unknown unknowns here. So I arrive at the same place.
Any other commissioners want to speak to that?
Mr. Anderson has.
Mr. Anderson has his hand raised, right?
I'm going to allow him to talk.
Sure.
You're enabled to speak, John, if you want to unmute.
All right, good morning, commissioners. Can you hear me okay?
Yes.
All right. Well, I agree with the I agree with Brian's general comments on 21-134. I don't think that it is that resolving the RTODD issue is dependent on also resolving the ambiguities with 21-134. I think it's a separate issue that can be dealt with separately. When I raised the issue originally, that the intent was simply to, point out that the issue exists. If the commission, the only thing that I could see that would be specifically connected to this particular study would be if the commission wanted to make the decision that a gift under an RTODD is not a specific gift. I suppose that could be an outcome, and that could be written into the RTODD statute that it's not a specific gift, and then this issue would not exist. But that's for the commission, obviously, to decide. As to the operation of 21-134 itself, I agree with Brian that I don't know that it's limited to RTODDs. I would say in his hypothetical involving a trust, I'm going to modify the hypothetical a little bit, because if let's say a person has set up a trust that only has a house in it, and the house is specifically is given or is intended to be given to a particular beneficiary. If that house is sold while the settlor is incapacitated, what would happen is that the proceeds from the sale would become assets of the trust. So the trust would own, instead of a house, it would own cash from the proceeds of the sale. So unless the trust were revoked or somehow amended while the settlor is incapacitated, there would be cash. When the settlor ultimately dies, there would be cash in the trust that could be used to satisfy the specific gift. So
I was wondering about that.
Yeah, so that would be, again, there may be scenarios where the trust might be revoked or something like that, but generally speaking, if the property was sold, the proceeds would fall into the trust rather than the settlor's probate estate.
Yeah, or the conservator could spend the asset.
That's right. I mean, and 21-134 certainly doesn't say what happens if the proceeds are spent for the conservatee's care and there's not enough money to satisfy the pecuniary gift. I think then the general rules of redemption would apply, or the general rules of abatement, I should say, would apply.
Yeah, I think it's possible that this issue would be rare and would, in most cases, take care of itself. But like Commissioner Carrillo said, I feel like there may be unknown unknowns. And I'd like to take a little bit more time to ventilate the question.
David?
Yeah, it also occurs to me that we could create a perverse and not good incentive here, that if we carve out this other provision, then a bad actor could figure out that they can obviate the terms of the instrument by doing something with the property, that's sort of the human willful version of an act of God or a fire. So it creates an incentive for a bad actor to act deliberately against the testator's or the trustee's intent, and obviously we don't want to do that.
Right.
Yeah.
So,
Oh, look, the house burned down. That's so sad. Or, oh, look, the house got accidentally sold to some third party. Bummer.
So does the commission okay with the idea of moving this issue off into a side study?
any concerns?
No,
I'm-
that's great.
Okay.
I'm going to call the roll out of an excess of procedural caution.
Oh, good idea.
Never entirely sure what constitutes a decision that needs to be roll call, but we might as well.
That
So
is-
Commissioner Carrillo,
Aye.
Commissioner Cubas,
Aye.
Commissioner Jenkins.
Aye.
Commissioner King,
Aye.
Commissioner McAllister,
Aye.
Commissioner Miller O'Brien,
Aye.
Commissioner Rubin,
Aye.
Commissioner Simpson.
Aye,
Thank you.
okay.
So the last main issue, which may also lead to, which will involve a question of what to do with the draft that was attached to the main memo, is this new issue that's raised in the supplement. Is that the dog that voted for you at the last meeting, Commissioner Cubas?
Yes, and I'm sorry. Let me put him outside. I apologize. He should be outdoors.
Okay.
That's all right. So this issue is has to do with which interests in property transferred by a revocable transfer on death deeds, or more specifically, stock co-op is where I start. If you use a revocable transfer on death deed to transfer an interest in a stock co-op, which interests in that property that pre-existed the transfer survive the transfer and remain enforceable? That's the question that is answered in the existing statute in, where did my notes go? Section, I think it's 5682. 5652. 5652B, as it exists today, 5652B essentially says that any interests in property that are of record at the time of the transferor's death remain enforceable against the property notwithstanding transfer by the RTODD. That's effectively the rule. So they have to be of record at the time of the transferor's death. And the implication is, or they're not enforceable against the property transferred by RTODD. So you have a bright line. And the commission had recommended in its follow-up study of the revocable transfer on death deed statute that that rule be relaxed slightly, so that rather than requiring that the interest be recorded at the time of the transferor's death, instead the cutoff would be 120 days after the beneficiary gives notice to heirs. Right, so you've got another 4 months after the transferor's death, give or take, in order to record your interest in the property and preserve its enforcement against that property when it transfers. One of the decisions the commission made at the last meeting, when we were looking specifically at stock co-ops, was to require that this notice to heirs that the beneficiary is required to give under the statute also be given to a stock cooperative if the interest transferred is in a stock cooperative. And when we talked about that, my express reasoning for that was this section, so that we know that stock cooperatives often have these important substantial restrictions on the use of property. We don't want them extinguished by an RTOD deed. Let's make sure the beneficiary gives notice to the stock co-op so the stock co-op can act to protect its restrictions. They can run down to the recorder's office. They got 4 months to record them. And that was the decision at the last meeting. And as I was drafting to prepare the draft, I started to feel uneasy about that. Because these restrictions are, like I said, they're pretty significant. And one of them, I think, is very significant, which is some stock co-ops are what's called a limited equity housing development, where the transfer value of the property is expressly limited to below market rate. And these are a mechanism for providing affordable housing. So if you buy into one of these LEHDs, you might be paying way below market rate, with the understanding that when you sell at way below market rate. So you don't get a windfall from it. And then the next buyer buys way below market rate, et cetera. So you really don't want that restriction to be terminated if somebody chooses to use an RTOD deed to pass their interest on to an heir. And while we acted to make this statute much less likely to produce that bad result by extending the period to 120 days, by requiring notice to the stock cooperative, it doesn't entirely preclude that bad result. Even with notice to the stock cooperative, somebody may just mess up. Stock cooperatives are a form of common interest development. And as we know from the study of common interest developments, they are typically being operated by homeowners who may not have any legal training or special expertise, and they're just doing their best. And legal mistakes in CIDs are not uncommon. So the statute leaves the door open to the possibility that the beneficiary serves the notice on the stock co-op, and whoever has the duty to staff the office when that notice arrives puts it on a pile of envelopes, and they don't get around to opening it for 4 months. And now their restrictions are by law inoperable. And that struck me as maybe an intolerable balance of sort of the equities of the situation, because these restrictions are so important. There's the transfer value restriction in LEHDs. There's also age restrictions. A lot of these are senior communities. A lot of these co-ops reserve the right to have board approval of any occupant. And many of them have a reserved right to repurchase on the death of an occupant, so that they can sort of exercise control over the transfer process and make sure that nothing goes sideways. So it occurred to me to think, well, maybe there ought to be an exception for stock co-ops so that they don't have to record their restrictions for them to remain enforceable after the transfer. And so that got me wondering, like, okay, what's the consequence of that? How bad would that be? And I started doing some research into general law on recording and priority of interests, etc. And spent a lot of time with Miller and Starr real estate treatise. And what I came away with is maybe it wouldn't be a problem. And there are a couple reasons for that. And I, unfortunately, the Land Title Association is not here today. I asked them about this and asked if they were going to have somebody here, and I guess it didn't work out. And that, I think, is maybe a reason to postpone final decision on these issues until December, give CLTA a chance to comment on this. So according to Miller and Starr, in California, there is a standard CLTA title insurance form policy. And this standard CLTA policy has standard exceptions to coverage. And one of those exceptions is they do not cover off-record interests that could be ascertained through inspection of the property or inquiry of the person in possession. Okay, which came as a surprise to me, because my general understanding was that their principal concern was about off-record interests, because they didn't want to wind up holding the bag if there was something off record that affected title. But as it turns out, it appears that they carve a lot of those out and don't insure against them. And so they are not liable to the insured for an off-record interest that was ascertainable through inspection or inquiry, in general terms. So the next question that occurred to me is, well, okay, so restrictions in a stock co-op, are those the kinds of interests in the property that are reasonably ascertainable through inspection or inquiry? And I think they are. One of the points that's discussed in Miller and Starr is that there's a lot of law around who is a bona fide purchaser. California, I'm going to back up out to general law a little bit. California is a race notice state, which means that in terms of interests in real property, the general rule is that the first person to record their interest has priority over an unrecorded interest, with an important exception. They can't have notice of that other interest. If they have notice of that other interest, they do not trump it by recording first. That's the notice part of race notice. And so the people who are protected by recordation are called bona fide purchasers or encumbrances. These are people who actually pay value. Donative recipients are not BFPs. So you have to pay value, and you have to also act in good faith and without notice. Good faith includes an element that you can't have notice, actual or constructive, of other interests. BFPs are not protected against interests of which they have actual or constructive notice. And what I found is that an element of that is that you're deemed to have constructive notice if the circumstances suggest you ought to investigate or inquire. Okay. And I think that if you're buying an interest in a stock co-op, that it's reasonable to assume that you need to investigate the scope of the interest you're acquiring. Because as I say in the memo, a stock co-op does not deed you a specified three-dimensional space in the world, right? Like most deeds do. It grants you a use right. The title retains, it is held by the stock co-op itself, and that you have a use right as a consequence of your stock certificate that you purchased and the surrounding governing documents. Like a lot of times there's a contractual agreement between the certificate holder and the stock co-op, and then there's also governing documents like the articles of incorporation and the bylaws of the stock cooperative. So if you're buying an interest in a stock co-op and you understand that's what you're buying, you cannot know the scope of the interest that you're acquiring without investigating the controlling documents. You can't even know which unit you're buying, or what rights you have to use the pool, or where you could park. To find those things out, you have to research off-record documents. And the other thing I say is that there's a dominant estate here. The stock co-op retains title of the interest that you have a right to use. And there's also law that says, in terms of who has constructive notice, that if you know there's joint ownership, you're on notice that you ought to inquire into what the rights of the other owner are. And here, that would mean checking out what are the retained rights of the stock cooperative. So the general take I took away from this, and I'll admit that a lot of this is new law to me. I've never looked hard at real estate law before in terms of this sort of conveyancing and recording and the scope of BFPs, et cetera. So I might be missing something. But my general sense is that under existing law, an off-record interest in property is nonetheless going to be enforceable against who would be a BFP, but for the fact that they have constructive notice that they ought to be conducting an investigation or inquiring of the person in possession. And so the upshot of all of that is that when I thought, like, okay, what consequence if these stock co-op restrictions remain enforceable? Well, maybe no consequence at all, because the title insurers are likely to have carved out their liability for that situation. And the purchaser or encumbrancer would likely have already been subject to continuing enforcement of those restrictions. And I should say one other idea that occurred to me when I was doing this research is that it seems like this BFP rule about notice creates this sort of bifurcation of the world. Either you have notice and you have liability for previously existing unrecorded interests, or you don't have notice, in which case you're a BFP and you don't have liability for those interests. In the first case, you fall into CLTA's exception, and so they don't insure you against that. In the second case, you don't have any liability, so they're not going to have to pay you anything as a consequence of those unrecorded interests. So where I landed on all of this is that I think that we could carve out these restrictions in a stock co-op, say that they are enforceable against the property after transfer without having had to been recorded during this 120-day period. And I don't think it would cause any operational problems or inequity for the title insurers or any subsequent purchaser or incumbency. Now, there's a broader implication that I'll set aside for now until we decide whether or not we're comfortable with that preliminary conclusion. Does this cause any concerns for anyone? Are there questions, or does it sound?
Comments, thoughts about?
Okay.
See any?
Do we want to ask Texcom? I know that
Sure.
they're not as much the experts on point as CLTA would have been, but be interested to hear the.
Mr. Anderson raised his hand.
Sure, I will weigh in. This is definitely, you want to hear from CLTA more than Texcom on this issue for sure. This memo hasn't been discussed at the Texcom level, so I'm giving you my personal thoughts. But I agree with the premise that, especially for stock cooperative, I think it would be there would be a high risk of adverse consequences if restrictions had to be recorded to be enforceable. I think there's just too many possibilities that would fall through the cracks, and if that then created problems for the stock cooperative, I think that would be unfortunate. So I agree with the basic premise that ideally those restrictions would remain enforced without the recordation requirement. That's all I have to say on the issue, basically.
Thank you.
Appreciate that. Thank you.
So as a preliminary question, not the final question, are commissioners feeling comfortable with the idea that the stock co-op restrictions should remain enforceable even if they aren't recorded?
It kind of makes, if I understand it correctly, it kind of makes sense to me. Other members, yeah, David?
Yeah, I mean, I'm looking at this two ways. From a legal point of view, this sounds like a usufruct because you have a right to use a property. But then it also occurred to me that the reality is, as we've discussed a few times, a lot of these entities are used by or specifically for the purpose of senior housing communities. And I'm not sure I know all the contours of the usufruct doctrine, and I'd be surprised if many of the older folks buying into these communities do. So it's, I think there's a consumer risk here that, a pair of seniors think, oh, great, we're buying a retirement condo. This will be our house. We will own it, or at least be renting it in sort of the colloquial conception of that. And they may be very surprised that the long document that they signed on purchase and didn't really read or understand prevents them from doing things like, I don't know, subletting it, or having a pet, or having a grandchild come and stay with them, or being able to will it to somebody or sell their interest, So I don't know how we deal with that, but I think there is that consumer protection concern.
Yeah, well, and CID law generally is under constant legislative pressure to protect consumers. You hear lots of horror stories, and the horror stories translate into bills.
Yeah, and I totally understand the exemption from the title insurance. So the title insurance company is basically saying, this is discoverable in your due diligence. You should go look at this stuff, and if you don't, that's not on us.
Mm-hmm.
Which and that's all well and good, but I'd be a little, I don't know if I would be able to grasp all the contours of one of these agreements if I read it, in the 5 minutes that I had to look at it for a signing session.
Yeah.
I think there's a trap for the unwary here.
Sort of at a pulling back out scale, that stock co-ops themselves, you're seeing a trap for the unwary, not necessarily these rules about how to administer a RTO-DD transfer of a stock co-op interest.
I'd just be worried about, the average person doing this without the assistance of somebody who is well-versed in this. And by well-versed, I mean, not me. Like I would struggle to figure out all the contours of this.
So
Therefore,
I think that, we are sort of at the midpoint of this idea in terms of feeling like the law ought to be changed to avoid accidental termination of interests in stock co-ops.
mhm.
Where I wound up, and this is again why I didn't make a recommendation for just like fixing it and approving the recommendation with the fix. Where I wound up is that maybe this has a broader implication beyond just stock co-ops. Because if general law is appropriate and adequate for stock co-ops, why wouldn't it be appropriate and adequate for other kinds of real property interests? So let's say that you've got a single family home that's being transferred by RTO-DD, and the owner of the home executed a contract with somebody giving them an option to purchase the property. And that person never recorded their option. So it's an off-record interest in the property. Under the RTO-DD statute, they have to record that in 120 days or it's ineffective, right? It's just gone. Under general law, you don't have to record it for it to remain enforceable if the bona fide purchaser or encumbrancer knew about it. They had notice, actual or constructive. I don't think constructive, it's going to be hard to argue for constructive notice of an off-record side contract. But suppose the purchaser knows that this person has the option. Under general law, that option would remain enforceable against them. Our statute would terminate it. And I don't know why, as a matter of policy, our statute should terminate that agreement if it wouldn't be terminated under general law. If it was just like a straight sale of the property, no death transfer at all. Or yeah, let's just say that. So I'm just selling it and the buyer knows that there's this option out there. That buyer is going to be subject to that option under general law. And, there is this large, deep, sophisticated body of law that deals with what kind of notice is going to be imputed to a purchaser or encumbrancer with respect to the enforceability of off-record interests. And as we know, CLTA has already built the terms of their contracts around that doctrine. The title insurance policies say, if there's an off-record interest that you ought to know about, we're not insuring that, right?
Mhm.
And if there is no reason for you to know about it, then you're not liable. And so under, heads or tails, the title insurer doesn't pay. And so this provision, 5652B, was part of sort of an underpinning in the RTO-DD statute way back when, 2006, whenever it was when we first drafted it, that was built on the notion that in order for property transferred by a revocable transfer on death deed to be marketable without a court order validating it, it had to be insurable. Title insurers had to be able to say, yes, we will ensure that this is good title in the beneficiary. Then the BFP is going to say, okay, good enough for me. If it turns out you're wrong, you'll pay me, so I'm going to go ahead and buy or encumber it. That was a fundamental principle of the original proposal, was that things have to be in the record in order to facilitate title insurance. And if it's not in the record, be it an off-record restriction or a conflicting instrument, if it's not in the record, it's not going to be enforceable against the property transferred by RTOD deed, because we need title insurers to be confident that they're not going to be surprised by these things and wind up holding the bag. I'm now wondering whether that underlying assumption was correct, or whether the existing law that says a bona fide purchaser is only liable for an off-record interest if they have actual or constructive notice, and title insurers are already carving that liability out of their policies, then I don't know that I don't know that any off-record interest is going to undermine the issuance of title insurance.
Yeah.
And so I'm wondering, like, this is sort of similar to what we went through at the last meeting, where we started picking at an issue in the context of stock co-ops and realized that it sort of unraveled the premises for RTOD deeds as a whole, with respect to these conflicting instruments. And now I'm wondering whether the same thing is happening here with respect to enforceability of restrictions, off-record restrictions. If we pick at this and conclude that there's no harm in making stock co-op restrictions enforceable, maybe the same is true for all off-record restrictions. That's why I'm not ready to make a recommendation, why I want to hear from CLTA. And I think we ought to take the time needed to think this through.
That makes sense to me too. You want to create unintended consequences.
And so if all of that is correct, then I don't think we're ready to vote to approve the final recommendation that's attached to the main memo. And instead, I will bring this back in December.
Is there any other members who have questions or comments, or want to take a different approach? Seeing none, hearing none. Okay, that makes sense. And we don't need to take a vote for that. We're not taking action
Right.
at this meeting on this particular issue. And we'll put some more thought and energy into it and reach out to some of the other stakeholders to help us sort of figure it out.
Can I say that the chair is requesting CLTA to comment on this, just to give it a little
Absolutely.
more heft?
Yes,
Okay.
yes. Okay, and speaking of which, Crystal is with us. And Crystal, are we correct that this is your last meeting?
Yes,
Yes. Well,
but who knows? I might sit in in the audience if there's just to follow up on some other stuff. Just
okay,
turn
you
this-
make sure to raise your hand so we can.
Right.
Yeah. No, we understand that you have an appointment to another body. So
Yeah.
congratulations.
Thank you.
And wish you the best on that. And I honestly, I learned a lot just when I first came on the commission by watching you and learned a lot from your comments. So
All right.
I've
Good.
appreciated having you part of this body.
Thank you. I appreciate that. Thank you, Chair, for recognizing me. And I'm looking forward to working with Access to Justice Commission. So kind of the same stuff, I think, but just more focused on courts and resources with Judicial Council. But like I said, I do plan to visit, and so you won't get rid of me entirely. I've dedicated a decade with just kind of forming relationships with a lot of you all, and I do feel very much connected and in spirit, and I am sad that I didn't get to touch and just, you know, and see you all in person, but I'm here. And as soon as I guess if we ever have meetings that collide and I'm in Sacramento, I'll definitely come look for you and peek my fin. Thank you, everyone.
Well, if
And move
you're-
a round of applause for Crystal.
Oh,
Yeah.
thank you. That's nice, everyone. Thank you.
And if in your new assignment, if you come across any misbehaving judges, I'm still in the CJP, so you let me know.
There you go.
We're gonna miss
Just,
you.
yeah, bridge resources.
And profound thanks from the staff, Crystal. 10 years of service.
Can you believe it? I can't. Victor, I think, mentioned, or when we first introduced ourselves to the new commissioners, when you mentioned it, Victor, I was like, I got my jaw open because I couldn't believe it.
Well, having served all 10 years with you, I wish you the best of luck. I'm going to miss our Uber rides to the airport. But since you live in Los Angeles, you know, we could always take an Uber ride to a restaurant. So I look forward to seeing you soon.
Good, thank you.
And I'll say that, you know, Kristen and Steve didn't have any material to present on this meeting, but they both chose to attend anyway because they wanted to see you off and wish you well.
Oh, you guys are trying to make me cry. It's not going to
Go
work.
ahead, do it. Try.
Awesome. Well,
I'm such a crybaby. No, and I just, when Kristen, you turned your light on, poor John and Mark are like, get on with the meeting, but you guys, thank you so much. Thank you.
Thank you.
Thank you. Thank you.
Thank you,
No, I
Crystal.
loved it. I loved every minute of it. That's, yeah, no, thank you all.
Thank you.
I want to make sure we're all here. when
Man,
he-
I've heard about babies growing up. I just honestly, that just goes to show you how fast time moves.
I know.
It moves so fast.
I used to have hair.
You still do, according to the gray screen. You're talking too much.
So my item's done. There's
Okay.
one other on the agenda that Barbara's
Yes,
responsible for.
from Barbara. So item the trial court restructuring issue.
Okay, so this is a memo about a letter that we received from Mark Lomax, who's an attorney in Los Angeles. He is with us today, and so I think it would be good if we could enable him to speak.
Okay.
And the memo focuses on his letter, but it has to do with the jurisdictional classification of a drug asset forfeiture proceeding and whether the statutes that relate to drug asset forfeiture proceedings should be amended to expressly state that any proceeding under those statutes is an unlimited civil case, regardless of the amount in controversy. And an unlimited civil case is a case that before trial court unification had to be brought in superior court. And so before trial court unification, what these statutes said is that these types of proceedings had to be brought in superior court. And that language at the time was sufficient to indicate, excuse me, that the case had to be treated as a superior court case, which meant things like it was appealable to the Court of Appeal. It was subject to certain kinds of court procedures. And it was not the kind of case that could be brought in municipal court, where different procedural rules apply, including different filing fees. There were limits on the amount of relief awardable. In general, the amount in controversy in a municipal court case was limited to $25,000. But the problem arose after the courts unified. We had to make clear what kinds of procedural rules applied to cases that used to be brought in municipal court that now could be brought in superior court instead. That was done by coining the term limited civil case and adjusting all of the references in the code to the municipal court. It did not involve reviewing every single reference to the superior courts, which was fortunate because there were a whole heck of a lot of them, and it would have been extraordinarily time consuming to review each one of those references. The superior court cases were just dealt with by calling everything other than a limited civil case would be an unlimited civil case. At the June meeting, the commission considered whether to go forward with the project that has been on its back burner list for a long time about reviewing every superior court reference in the codes and figuring out whether it was necessary to add some language about the proceeding, if there was a proceeding discussed in connection with that superior court reference, whether to add language to the code section indicating that the proceeding was an unlimited civil case. The commission decided to adopt a no review and very limited treatment approach, mostly in recognition of the fact that this kind of project would, if pursued rigorously, would just consume an enormous amount of the commission's resources, and the returns on that seem to be potentially not worth the effort. That decision prompted Mr. Lomax to suggest that in the context of a drug asset forfeiture, providing guidance regarding jurisdictional classification would be particularly helpful because there's a greater than normal possibility of confusion about jurisdictional classification in that context. Largely, I think his point was that the $25,000 limit that applied to a municipal court case and now applies to a limited civil case is the same dollar amount as the limit between a judicial and a non-judicial foreclosure under the drug asset forfeiture statutes. And because there's that overlap where there's the $25,000 limit in two different contexts in those statutes, there are occasional times when there is confusion about the jurisdictional limit, and it would be helpful to provide some express language on it in the codes. I'm summarizing what Mr. Lomax said, and I think it at this point would be helpful to hear from him.
Okay, Mr. Lomax?
I don't think I can add anything. I think Ms. Gale has expressed it quite well in her memo and in her oral presentation.
Okay.
I just think this is an example of one of those cases where the commission's action would be helpful.
So either for Mr. Lomax or for Barbara, I'm not sure. I mean, I'm not a lawyer. What's the practical consequence of this confusion? Is it, to whom would one send an appeal if you don't like whatever the decision is? Is this a question of, procedural differences between limited and unlimited cases?
It is a question of procedural differences, I think.
And are there procedural differences that are a big deal?
Yes.
Yes, and
Yeah.
it can be everything from limits on the amount of discovery to the types of pleadings allowable, to the appeal path, whether it goes to the Court of Appeal or an appeal goes to the appellate division of the Superior Court. I mean, minor is the filing fee. The limits on the amount of relief and the kinds of relief awardable are also significant differences between municipal court or traditional municipal court cases and traditional superior court cases, which are now the same as limited and unlimited civil cases. There are a lot of consequences to the jurisdictional classification.
And I presume that because of the existence of this ambiguity, somebody's making decisions now about where or about how to treat them. Are those differences in different counties, or
They would
guess-
initially be made when a claim opposing a forfeiture is filed in court, and that would be a clerk probably who would see it and might possibly incorrectly classify a forfeiture proceeding as a limited proceeding. But there's a further wrinkle, which I
Mr.
didn't want to get into, regarding some of these forfeiture proceedings. They're civil in nature, have to be tried with a criminal proceeding at the same time. So you have an added wrinkle of complexity. So I just think it would be helpful to provide the guidance explicitly to courts. They could look to the code section. It says this is an unlimited proceeding, and they wouldn't have to do any further research.
If I may too, when I was looking at this, I was thinking that I know for LA County, the presiding judge for each court that this would be presented to would make that decision. So this would be a matter that the clerk would not typically make because there is no statutory guidance. And there wouldn't be any local rules. So they would have to confer with the presiding judge.
My experience in the court was LA Superior Court has a huge volume of civil filings of various types of lawsuits, all sorts of special proceedings. And those decisions are not made with every time a case is filed or a claim is filed or a special proceeding is filed. Clerk makes an initial determination. There may be a review by a judge, but this process, they assign a different series of case numbers to limited cases versus unlimited cases. So there are all sorts of areas in this process where you could misdesignate a forfeiture proceeding as limited, and it might not be caught until quite a bit down the road when it finally does make it to a courtroom. So I just think there's very little investment in this, very little that is lost if you do it, but a lot to be gained by expressly clarifying what the jurisdictional classification of these proceedings is.
Commissioner Carrillo.
This seems like a problem to me. It seems like a reasonable fix. It doesn't seem all that difficult. It's an incremental fix. I recognize that there might be broader reforms here in the area of civil asset forfeiture, but I wouldn't want to let the perfect be the enemy of the good. This is doable. It's reasonable. Let's fix a problem.
I do see this as a problem with us making that decision. I think the decision is a substantial change in the law because I do believe that it rests currently with the deference, judicial deference of the different courts. And I, like Mr. Lomax mentioned, I do believe I've had a case like this. And it was a case that fell between jurisdictions because it was a criminal matter, federal matter versus a question of how the state should oversee or manage the issue, if at all. So, and it was ultimately decided by the LA Superior Court. But I just know, just from on the back end of it, it would be an issue that the presiding judge for the different courthouses would have within their authority to decide. If we create a statutory rule or to tweak it, we are taking a system of how courts manage those. And it's not something, I just think it's a study and or consideration that might even benefit from our partners with the criminal side of the commission to consider as well.
But I think that variation is exactly the problem. If the law is as clear as Mr. Lomax suggested is, it's not something that should be at the discretion of the various PJs, the 58 counties. And that leaving it up to that discretion and creating that kind of variability, that's exactly the problem to avoid.
But that wouldn't be something that the commission would have authority to.
No, we'd be
resolve.
making a suggestion, obviously.
Barbara,
I don't think this is a discretionary matter. This is a matter that by virtue of both the California Constitution, which determines the appeal path, that's the provision on the appellate jurisdiction, says that if it was within the appellate jurisdiction of the Court of Appeal on January 1, 1995, it must be kept that way. And so by Constitution, the appeal path has to stay the same way it was before trial court unification. And if you read the definition of a limited civil case in the Code of Civil Procedure, Section 85, that too makes clear that a case can only be treated as a limited civil case if it met the criteria for being treated as a municipal court case before trial court unification. So it's not discretionary. It's just that on the face of the statute that deals with drug asset forfeitures, it does not expressly say how that kind of proceeding has to be treated. You have to look harder at the codes and at the history of trial court unification to discern the proper jurisdictional classification. But the statutes do say that if you read them carefully, that they do dictate how you treat a drug asset forfeiture proceeding, and it has to be treated as an unlimited civil case, regardless of the amount in controversy. There's no question about that. It's just not as explicit as it should be.
so when I was in my days in the legislature, I do recall, and I assume it's still the case, that the whole issue of asset forfeiture is a controversial one.
Yes, and that's our concern, is that at a staff level, we wanted to make sure that the commission understands that drug asset forfeiture proceedings are quite controversial. There are a lot of states that are in the process of rethinking their laws governing drug asset forfeitures. And there's certainly, I think, discussion within California along the same lines. And so there's, whether to polish to some extent the existing California statute by making this proposed change is a question about, whether that's a good way to spend the commission's resources and the legislature's resources in considering that kind of change, whether it might get hung up in the legislative process by people who have more overarching concerns about the drug asset forfeitures rules. That's an important set of policy considerations for the commission to take into account in how it decides to proceed. And of course, it should take into account the fact that we now have this sister entity within the commission, the Committee on Revision of the Penal Code, which this kind of I don't think they would be interested in this kind of narrow procedural issue relating to drug asset forfeiture, but they might be at some point, it might be within their jurisdiction to look more broadly at drug asset forfeiture proceedings.
David.
I think we're about to lose Commissioner Cubas in about 10 minutes. So with the chair's permission, I'll move the memo so that Commissioner Cubas can be part of the discussion before we take a vote, if that's possible.
And when you say move the memo, what
the proposed change that's, or the draft change. I don't know if it's a suggestion from the staff.
I don't think it is, if I remember correctly, but Barbara?
I noticed that Mr. Lomax has his hand raised, and I thought we should give him an opportunity.
And I'll hold my motion for a moment.
Okay,
Okay.
Mr. Lomax?
I would just like to say that I agree with the interpretation of Ms. Gale, that jurisdictional classification is not discretionary. A judge cannot make that determination. Case law currently is that any case that was filed in Superior Court before unification is, after unification, an unlimited case. So anyone looking at drug asset forfeiture proceedings and went through the somewhat convoluted process of examining the statutes and the legislation would ultimately conclude that drug asset forfeiture proceedings today must be classified as unlimited. The problem is that most judges and attorneys are not familiar with the code sections and the legislation, and to go through that process. And I think that some of these cases are getting misclassified. So that is all I'm suggesting, is that we make explicit, or that you make explicit, that these proceedings are currently unlimited proceedings. Or cases.
Victor had raised his hand.
Yeah, I want to thank Mr. Lomax for bringing this to our attention. I think the points he makes are excellent. I agree with the concept that it's non-discretionary, but I'm very sympathetic to the concept that we created another commission here that's dealing with criminal matters. And to the extent that they may or may not want to look into drug forfeiture, I guess we believe they wouldn't look at anything this narrow or small, because they look at bigger issues. But nonetheless, the question could be raised as well, why aren't you doing more, or why are you in these other areas? And that because we've made this huge distinction that this panel of 10 commissioners will deal with civil matters, and the other panel will deal with penal or criminal matters, I would feel more comfortable in approving this recommendation if we had some feedback from our sister commission as to whether or not there's any objection. I don't know what mechanism that would be, if it's just a phone call or email to the chair of that group. But I'm open to suggestions, Brian. But I just like to check in with them that they aren't bothered by this side of the house making such a recommendation.
David.
Well, then I think what I'll do is I'll make a motion that staff come back with a draft recommendation, and that as part of the process of putting that together, they reach out to our sister commission and let them know that we're looking at this and see what they say.
Barbara?
I would say first that we already have had discussions at the staff level with the staff for the committee. They're aware that this is under discussion. They did have, I think, concerns to some extent along the lines that we raised in the memo without getting into, a lot of detail. But, whether you want us to take it more formally to the committee level, we did not do it beyond the staff discussions.
Yeah,
Well, I think if we, sorry, go ahead, Victor.
I'm inclined to think this is a committee level decision, because the population, fallout of us entering this area just may raise all sorts of questions for them as to why aren't they looking at this issue, why aren't they looking at that issue, and so forth. So while I appreciate the staff input, and I know you guys are always very diligent about that, at the end of the day, it's those committee members and us commission members who have to have our names or reputations on the line. And therefore, if there's a mechanism to do that, if you could check if the committee itself would have any opposition. And if they don't, thank you, Mr. Lomax, for bringing this to our attention. I think it's a great suggestion.
Yeah, I was going to say, Victor, I had the same thought, and it seems to me like if our sister body finds out that our staff is working on a draft recommendation that we will actually consider, then that may be the kind of thing that does elevate it to their official attention level, and their feelings can be worked into the staff draft recommendation, and then we'll have that at our next meeting. We can decide whether it's appropriate for us to do this or not.
I heard some suggestion that it might be sufficient to talk to the chair of the committee. And the reason I asked that is that, as I mentioned, they've had their last meeting for the year already. So if we're going to reconsider this in December, we won't have an opportunity to talk to the full committee about it.
So maybe we have to do this in January.
Yeah.
So do you want a motion for us to tell you to go talk to the chair or that's all I can do?
I'd take a friendly amendment, or I would add that to my motion.
Well, I'm asking, is talking to the chair sufficient?
I think so, and Ms. Cubis has to leave, so if we all think so, maybe we just do that.
Okay. So it would be to ask our staff to get in contact with the commission, with the chair of the committee, and get let them know that this is an issue that came to us. What the proposed action of the presenter was, and is, what their views are. Is this something that they think is in their wheelhouse? Is this something that's they don't intend to deal with, and kind of figure out if it's appropriate for us to take some action in this area?
Yeah, and I'd like to see that in the form of a draft recommendation, so that it won't just be a handshake phone call.
Okay.
I'd rather see that in the memo, what position they
This
take.
is okay. Yeah, okay. So this is the proposed statutory action that's being proposed, and what do you guys think of it?
Right.
Barbara?
Do you want, if the chairs of the committee does not want the commission to get involved in this issue, do you still want to see a draft of a tentative recommendation?
That would be great.
I think so. I mean, we still, as a
Less this
commission,
issue?
would need, as a commission, we would need to make the decision about whether we want to act or not. So we're not giving the chair of the committee veto authority over our decisions. But we certainly, it's their views are something we'd want to take into consideration. Or it may be something ultimately we want to talk to the legislature about.
Okay, so
Ahead of time.
what you would like to see for the next meeting is a draft of a tentative recommendation to implement Mr. Lomax's suggestion, plus a cover memo that says what the committee of the chair of the committee of the revision of the penal code has to say about whether how he feels about the commission proceeding with this draft.
Yes, that sounds right.
Right.
Could I ask about one minor possible modification of that plan, which is
Sure.
if it makes sense to just convey the chair's position orally at the meeting rather than in the memo? It might just become sort of constraining to have to figure out how to express that informal phone call in a permanent memorialized memo.
That's fine. But I agree with Rick, procedurally, it's important for us to record in our draft that we reached out to them, so that we look like we're being respectful and doing our jobs appropriately.
Okay. Is that something we need to take a vote on?
No, because we're not actually
Yeah.
deciding anything right now. You're
Right.
just giving staff direction on how to further develop the idea.
Okay. That makes sense. So is there any objection from any members with respect to proceeding that way?
I
Seeing none
just
here.
don't know how staff, I mean, I don't know. Anyway, okay. I'm going to lodge an objection because I don't know how Barbara can work with, I get it that it's important to proceed forward. We're talking about 30 days maybe in terms of not meeting the target date of getting something in like a tentative. And then we had already talked last meeting about how the holidays are going to even impact people's ability to review tentative. So I just think it's okay to bring back an oral commentary regarding what the criminal side of our commission has to say, and then interpret or incorporate that in the next, decision in terms of what staff should do for the following meeting. I don't know.
I think in favor of the idea of doing a draft tentative recommendation is that I don't think it would be that hard. And it would give something concrete for the chair of the committee to look at, to really see clearly what we have on the table.
Okay. I just wasn't tracking that, so I wasn't understanding. Okay.
I appreciate your concern about the staff workload. I agree with Brian. In this case, in part because Mr. Lomax's letter was so clear and well supported, preparing a draft of a tentative recommendation is not going to be too difficult for me.
Okay, thank you. So with that comment, we'll get in contact with the committee and sort of see where they are.
Yep.
Okay.
That's it.
That's the end of our agenda. And any other business to come before the commission?
I may email you all. I have to go run
I'd
out
say
to the
we
court
wish-
today. So I still might email you. You're gonna say, oh my God, we can't get rid of her. Because I'm just gonna run it by.
Email or call or
Anytime.
whatever you want.
All right.
Anytime.
Well,
Always-
thank you both,
always welcome.
Commissioner Miller O'Brien and Commissioner Rubin for
Yep,
being diligent and helpful commissioners.
yep. Exactly. We will miss you. We will miss you.
I'm gonna miss you all. Bye. You guys,
Stay
thank
healthy.
you.
Take care.
Kristen,
Bye.
Steve. Thank you.
Happy
Can't even
holidays
see
to
me.
everybody.
Background.
Yes,
Bye.
happy holidays.
Bye, everyone.
Bye.
Thanks.
Bye. Thank you, everyone.